Well, good afternoon, everyone. I'm Deborah Healey, co-director of the Herbert Smith Freehills International Business and Economic Law Centre and deputy co-director of the Tsinghua UNSW Joint Research Centre for International, Commercial and Economic Law, the JCICEL. I'm delighted to welcome you to the second panel of our 2022 conference. I begin today by acknowledging the traditional custodians of the lands on which we meet today, the Bedigal and Gadigal people, for where UNSW stands, and I pay my respects to the elders past and present. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders present here today. Before we start, I would really like to thank Tsinghua Law School colleagues who are participating in the conference. We value our collaborative relationship with our Tsinghua colleagues very much, so it's great to see you all here today. I'll introduce each panellist before they speak, and our format is our panellists will each speak for about 11 minutes before we open up for questions. So look, I will now move to a brief description of the conference. It's the second session of our annual conference, and it's a pleasure to be here to discuss important issues in digital and other areas of commercial and competition law. The first two sessions will focus on aspects of competition regulation in the context of the increasing prominence of the digital environment. And I will be the first speaker. As I said, I'm a professor at UNSW Law and co-director of the two centres. My research and teaching focus on competition law and policy in Australia, China, Hong Kong and the ASEAN nations, and I have written widely about them over a long period of time. So I won't talk any more about myself. My topic today is developments in digital regulation in the Asia Pacific. And I'd like to start by saying that competition law has been subsumed for quite some time now, probably at least 5 years, over a re-examination of traditional presumptions and rules, which is brought about by both competition law generally and also particularly by the digital environment. Many market characteristics we've taken for granted for such a long time become obsolete in a digital platform environment. Multiple solutions are currently being implemented or proposed in various jurisdictions, and I'll work through some of these very briefly in my presentation. Associate Professor Jun Long spoke in the first session on regulatory design, and really this presentation focuses on regulatory design. Next slide, please. So the content of this presentation is set out here. I won't touch on China because Professor Zhang Chenying will deal with it, but I would observe that in relation to the digital environment and regulation of digital competition, China is addressing the area with vigour, both in terms of the amendments that it's recently made to the anti-monopoly law and in its enforcement. Next slide, please. What I've tried to do in this slide, and I've been informed by one of the more recent OECD reports on patterns and approaches of individual digital regulators, I've listed the sorts of, the World Bank report, not the OECD report. These are the sorts of things that make digital markets different from other markets. Where large digital platforms are involved, markets are multi-sided with strong network effects. There's substantial economies of scale and scope, reliance on huge amounts of use data, and particularly from consumers. There are likely to be high switching costs, and there are often important intellectual property rights involved. The costs of using these digital platforms are usually low or zero for consumers, although they may need to give up large amounts of their data to access the services. The services are all about disruptive innovation. They tend to come into a market and take it on in an unregulated fashion, whereas existing operators in the market, if there are any, are bound by rules and regulations which often don't apply to the digital platforms. They have business models. Digital platforms have business models which rely on vertical integration and conglomerate business models. Take a look, for example, at Amazon. And a lot of what they do is competing for the market, not competing in the market. If they are very successful, they entrench themselves in a way which means that it's almost impossible for other competitors to actually get into the market. So barriers to entry are very high. And also, authorities require substantial expertise in digital markets. Now, if you're looking at merger-specific issues, what I would say is that it's always difficult to tell whether a merger is going to have a substantial impact on competition, but it's even harder in a digital environment where it's hard to know whether the acquirer is taking over a small company to wipe it out as a potential competitor, or to actually develop and use it. And that's a really big problem. The focus on major digital platforms is different in every country because each of us has a different platform in our country. You know, Australia doesn't have much, Amazon doesn't have big market power in Australia. Google doesn't exist in China. So those sorts of things are important. And data is a new source of market power, and privacy is a new theory of harm. Hurting privacy is a new theory of harm. So next slide, please. You see, I'm going to have not enough time here. So I will cut to the chase and say that all jurisdictions in Asia Pacific have competition laws, but ex post enforcement of those laws really doesn't solve a lot of digital problems because markets are dynamic and companies move to other methodologies before the court case is resolved, and they fight things very strenuously because they have a lot of money. So traditional court proceedings take too long, and I'll just revert to the US experience. I was in a conference a few weeks ago where a former FTC chair said that the cases that are running in the US will take at least 10 years to complete. So you can see that that's not going to be a viable way of dealing with a lot of this. So a lot of jurisdictions are looking at ex ante regulation and ex post regulation to supplement competition law. Next, please. So there are digital developments in most countries. I've looked at all of the ASEAN jurisdictions, Japan, Korea, and China. There's really no specific competition regulation in places other than China focusing on digital, although they've all looked at reports and they all have some cases. Most of the regulation that's implemented is about data protection and privacy, and that's because in a lot of jurisdictions at the moment that's a priority. There's been vigorous enforcement against platforms in Korea, Japan, and Singapore, and also China. Next slide, please. So I thought I'd focus on developments in Australia because they have been quite significant. And that's against the background of our competition regulator, the ACCC, enforcing competition and consumer law. So it protects business and consumers and has a broader remit than there is for a competition regulator in a number of countries. That's actually quite beneficial in this case. So we had our digital platforms inquiry, which reported in 2019, and it found that Google and Facebook had substantial market power in the supply of general search and social media services in Australia. And it was a more limited inquiry, but it did find that. Since then, the government was so impressed with what was done in the digital platforms inquiry, and what they did there was they took a broad brush approach. The Competition and Consumer Commission, the ACCC, would not do everything. It would work in conjunction with privacy authorities and others to create a web which would catch digital platforms. At the moment, the ACCC is concerned about the ability of enforcement action to address systematic competition and consumer concerns. And the government funded the ACCC to do the Digital Platform Services Inquiry, another one, which is reporting on a 6-monthly basis. And I could go into that, but they've done inquiries in a range of areas. In September 2022, the ACCC was due to hand to the Treasurer a report on proposing legislation in all of the areas that it had found were a problem in its previous 5 or 6 monthly reports, interim reports. Now, I don't know whether that's been done, but it's certainly not released yet. Next slide, please. Oh, and also in Australia, we've had cases. We've got a new news media and digital platform mandatory bargaining code, where digital platforms who are designated have to pay news providers for using their content. So that's useful. We've had various cases. Most have been settled. Most have been about misleading consumers about what's being done with their information. So we're doing a lot in Australia. I just thought I'd also mention, next slide, please, the Digital Market Act in the EU. And what that does is it imposes obligations on gatekeepers. So gatekeepers who are large online platforms who are designated, and they've got to have operate in a number of European countries and have a strong intermediation position. That means they have to link a large business user base to a number of other businesses in an entrenched and durable position. So this act will apply to them, and they need to be designated. But one thinks that will include the major platforms. What it does is it sets up a list of do's and don'ts, and they allow third parties to interoperate with gatekeeper services in some situations. It allows business users to access data that they generate when they're doing business with the gatekeeper, and to conclude contracts with their users on the platform. They can't treat their own, gatekeepers can't treat their own products and services more favourably than other people's products and services. They can't prevent customers from linking to businesses outside the gatekeeper's platform, and they can't prevent the uninstallation of apps which the gatekeeper has installed. And the Commission proposing to conduct market studies to work out who should be a gatekeeper and update the obligations of gatekeepers and design appropriate remedies. Now, gatekeepers who breach the Digital Markets Act will be fined 10% of their turnover worldwide, and there will be other remedies. But this will give gatekeepers more certainty about their obligations than having them go through these cases under the competition law, which may or may not go one way or the other. Next slide, please. And this is my last slide. I know my time is up. What I would say is much is happening overall in the Asia Pacific region, but one of the things I think is really important is the importance of convergence of various jurisdictions. Everybody's doing their own thing at the moment. They may be influenced by what's happening overseas, but they're doing their own thing. And jurisdictional convergence is really important because efficiencies may be lost and compliance costs will rise. So I think that's something we all need to be thinking about, perhaps through some organisation like the International Competition Network. And I will leave that with you. So that is what I wanted to say about what's happening in digital at breakneck speed. The next speaker, I'll now introduce Professor Chenying Zhang. She joined Tsinghua Law School in 2003. She's a professor and director of the Centre for Competition Law at the law school. She has a PhD in law, LLM, LLB, and Bachelor of Economics from Peking University, has visited Harvard Law School as a Fulbright scholar, and her main areas are antitrust law and economics, corporations and bankruptcy, and she is a consultant of the State Competition Commission in China, and her topic is revision of Chinese antitrust law and market regulation. So please welcome Professor Chenying.
Thank you, Deborah. Distinguished Professor Healey, dear friends, it's my pleasure to have this opportunity to share my idea with competition and digital regulation. My presentation will start from the background of digital regulation in China. Next slide, please. Chinese antitrust law was introduced in 2007 and came into force on August 1st next year. Compared with other jurisdictions, it started late, but it has played an important role in maintaining the order of free and fair competition. Next slide, please. Here I would like to give you some status to talk about the practice in China. From 2012 to 2021, 195 cases of monopoly agreements and 82 cases of abuse of dominance were deemed as breaching the law. Next slide, please. Yes. During the last 5 years, that's from 2018 to 2021, the fines for agreements cases total is 2.2 billion RMB, and the fines for abuse of case amounted to 36 billion RMB, including the abuse of dominance cases of Alibaba and Meituan. Next slide, please. Yes, and next. You can find that here is a very high amount of fine in year 2021 because the Alibaba was imposed a fine beyond 18 billion RMB. That's the second largest fine in the world. At present, a relatively complete antitrust legal system has been formed, which is composed of one antitrust law, one administrative regulation, 5 department regulation, and 8 guidelines. Including these 8 guidelines, one is specific toward the platform. After more than 10 years of practice, the antitrust legal framework and main system are available as a whole. However, with the economic development, some problems have been emerged in the implementation of the antitrust law, especially with the rapid development of new business forms, such as platform economy. Some large platform operators abuse their advantages, such as data, technology, and capital to implement monopoly behaviors. Therefore, it is since 2020 to revise the antitrust law. On June 24, 2022, the Standing Committee of the National People's Congress adopted a revised version. It came into force on August 1st this year. That's about 3 months ago. Next slide, please. Compared with the Compared with the old law, there is no change in the structure of chapter arrangements for the revised version, which states still 8 chapters. But the articles have been increased from 57 to 70. 13 articles have been added to the law, and 23 articles have been modified. The emphasis is on the addition of encouraging innovation for the purpose in Article 1. It enriches the target of antitrust law with the aim of promoting the good interaction between fair competition and innovation development. Obviously, it is important in the digital area. Next slide, please. Today's information revolution has fundamentally reshaped the way of production, life, and behavior, which have been shaped by the industrial and commercial society. This has caused systematic changes in the whole society. Internet technology is the basis of platform to realize resource integration, of which the core element is data. The platform is also the carrier to realize data interaction and generate value. Therefore, the platform and the digital economy come into being. There is a practical causation relationship. In recent years, what the EU and the US enforced the law on digital economy companies such as Facebook, Google, and Amazon are also on the basis of this international logic. Many cases was mentioned by Professor Healey and the gatekeeper regulation just a moment ago. For more than a decade, Chinese platform economy has experienced a rapid development. As a result, it has formed an ecosystem with some super large platforms as a core, and even become the barrier of data flowing and do harm to innovation. Next slide, please. There are many highlights in the revision of the antitrust law, which embody the value of innovation. Specifically, Article 1 of the antitrust law as the purpose for encouraging innovation. Second, the general provision on data, algorithms, technology, capital advantages, and platform provide rules in principle. Third, to give special concerns on the abuse of dominance in the digital economy area. In addition, the supporting regulation of the antitrust law are also under revision, many of which reflect the value of the innovation on various levels. Next slide, please. There is no doubt that innovation is the driving force for the development of society. There are many ways and the level of framework to encourage innovation, such as the protection system of IP. Then, under the system of antitrust law, how to make encouraging innovation into practice. What is the difference among the paths to encourage innovation? Antitrust law, IP law, and the anti-unfair competition law. I think to answer these questions, the following points need to be clarified in advance. Next slide, please. Number one, how to balance the relationship between innovation and the competition. From Schumpeter to Arrow, there are different views on large enterprises or small companies, which are more innovative. There is a great debate about the relationship between competition and innovation. Some people believe that the two are conflict. Competition and innovation may be the same reason for the both parties to the lawsuit at the same time. Some scholars think that the two are juxtaposed. Some people think it is a relationship between purpose and means, that is a subordination. I believe that the relationship between innovation and competitive incentive is complex and interactive, but not conflicting. Number 2, the theory of innovation damage should be introduced to assess the possible damage to innovation. At the same time, innovation defense should also be included. This theory should also be adopted in specific items such as killing acquisition in the concentration control. Number 3, although data circulation should be encouraged, the reasonability in the circulation should not be ignored. Otherwise, free riding or improper interface will occur, which is not conducive to the use of data. Number 4, market supervision should adhere to the principle of inclusiveness and prudence, fully aware of the specific character of the digital economy. Thus, the antitrust regulation on the platform economy should be special. Next slide, please. Judging from the ranking of the global top 500 companies by market value in last 2 years, the digital economy has achieved outstanding performance and has a free space to further development. This is inevitable of the times. We are facing the same topic. What we should do is fully understand its objective laws, lay the foundation for the goal of market order, regulate the digital economy according to its characteristics, and build a thematic balance between innovation and order. Thank you for your listening. That's my idea. Thank you, Deborah.
Thank you very much, Professor Zhang, for your interesting analysis of issues relating to digital competition and your discussion about the anti-monopoly law of China. We'll now turn to our next speaker, and our next speaker is Dr. Xue Bai, who was awarded a PhD in law in 2021, and she conducted doctrinal research on reform of Chinese state-owned enterprises, what China can learn from the practice of competitive neutrality policy in Australia. Prior to commencing her PhD, Dr. Bai was awarded her LLB and LLM degrees in law at Beijing Jiaotong University. Her current research is in the area of competition law and policy, and her recently co-authored article is published in the International and Comparative Law Quarterly on China's SOE reform using WTO rules to build a market economy. Thank you very much, Dr. Bai.
First, I would like to thank you, JCICEL, for inviting me to participate in today's panel. My presentation today is largely based on a journal article I co-authored with Professor Deborah Healey. In this article, we did a detailed comparative study on the similarity and the differences between Australia and China when conducting competition impact assessment in practice. Due to the time limitation in today's presentation, I will briefly touch upon two main points. Next slide, please. What is competition impact assessment and why does it matter? And how China conduct competition impact assessment in practice. Next slide, please. Yep. Government intervene in market for many reasons and many ways. For example, government implementing laws, regulations, and rules to achieve specific policy objectives, such as protect public health, especially during COVID-19 pandemic. However, without careful assessment, many of those regulations may unnecessarily restrict competition in the market, for example, by limiting the number or type of suppliers in the market or limiting the ability of suppliers to compete. Government everywhere are increasingly interested in assessing the effect of their policy to competition. Competition impact assessments thus provide a framework to help government integrate the regulatory effect on competitiveness into decision-making process. In particular, competition impact aim to identify and mitigate the potential anti-competitive impact of public policies in practice. In many cases, the same government policy objectives can be achieved by adopt or alternative, less anti-competitive models. It is also useful to discuss the difference between regulatory impact assessment and competition impact assessment briefly. In general, competition impact assessment is designed to provide a more quantitative judgment about the likely effect on competition, while regulation impact assessment have a more broader focus, which not only focus on competition, but also examine impact on environmental factors exact. That said, in Australia, competition impact assessment forms as part of regulatory impact assessment, while in China, fair competition review system, which I will be talk about later on, focused on the impact of various regulation on competition. As you can see, fair competition review system in China offers a detailed prescription on the review procedure, review standards and exemptions, and third-party assessment and supervision rules. In essence, the fair competition review system rests on the premises that government authority should not issue policies that restrict competition unless it is justified on the ground of which I have listed here: national security related circumstance, cultural security, technology security, and national defense, social security, and so on. The implementation of fair competition review system in China has been comprehensive, with set of supporting policies and the mechanism that been established to facilitate the development of fair competition review system. The recent amendment of anti-monopoly law, just like as noted by Professor Chenying Zhang, have further underscored the importance of fair competition review system. In particular, the amended anti-monopoly law has incorporated a fair competition review provision into the legislation. It also sent signals to all Chinese government authorities that fail to carry out such a review may face legal sanctions of anti-monopoly law. It is still early to see whether the introduction of fair competition review can formulate a culture change in regulatory making in China. However, before going into the detail of how fair competition review is enforced in practice, I would like to point out the possible reasons why China decided to implement such a policy. The opinions on establishing fair competition review system noted that standardizing relevant government activities, preventing the introduction of policy measures that exclude or restrain competition, and gradually clean up and abolishing provisions and practice that hinder fair competition and development of unified national market. I would like to point out it seems odd for competition law experts from other jurisdictions that competition law in China are designed to protect fair competition rather than protect competition or competitive process. In a sense, jurisdictions with goal of protecting fair competitions need to answer a question that is the question of fair to whom. In general, the discussion of fair competitions is often associated with the ideology of whether the competition policy is enacted to protect certain type of competitors. I also like to point out the unified national market. The enforcement of anti-monopoly law, as indicated by Professor Chenying Zhang, has been a significant step to promote a single market in China. Similar rationale can be observed in Australia when there is a national competition review going on. One of the aim is to achieve a single market of Australia. However, in anti-monopoly law, anti-monopoly law has dedicated a chapter to address a various form of anti-monopoly law, administrative monopoly. The adoption of fair competition review, in a sense, is complementary to anti-monopoly law to achieve a single market. And I will briefly touch upon the scope, as I listed in the PowerPoint slides. In Australia, the competition impact assessment covers all rules endorsed by government, which include legislations, policy rules. However, fair competition review system in China does not apply laws that formulated by national legislative authorities. This is one potential difference between scope. And next slide, please. Exemptions is similar because it all provides, both Australia and China ask for anti-competitive policy should not be implemented unless it is justified on the ground listed above. And I would like to touch upon, before I finishing, the institutional setting. The review body, like under the fair competition review system in China, is government policy department. And there is a complementary design of the rule of the third party, and government under certain circumstances are required to consult a third party, which often is composed with competition law expert. And the review standards is largely in line. Review standards for Chinese fair competition review system is largely in line with the factor listed by OECD competition assessment checklist. However, like a fair competition review system in China have additional outside mechanism in place. For example, government are required to undertake a regular post-implementary review to evaluate the impact of all policies. Another supervision of fair competition review in China is SAMR. Is the competition authority in China can randomly selective implemented policy to check if fair competition review has been conducted or whether it's being applied appropriately. And in addition, to encourage public participant, individuals are encouraged to make a complaint, or like what we call it informant, if they believe certain rules are not have breached the fair competition review system. So in general, I think fair competition review will in China will force a culture change in China's regulatory environment? Thank you. Sorry, I'm a bit running a bit over time.
No, thank you, Sophia. You're perfectly on time. Thank you for the participants so far for being on time. They must know I'm very tough on these sorts of things. I always come back to people because I want to make sure that everyone has an opportunity to speak, and then we have an opportunity for questions, which our participants really like. Look, I'd like to come down now to our next speaker, who is Associate Professor Ge Jiang. And Xue Jiang is an Associate Professor at Tsinghua Law School who obtained her LLB and LLM from Wuhan and an LLM and PhD from the University of Saarland in Germany. Her interest in research looks generally at IP, including misappropriation doctrines, employee inventions, platform liability, and damages. She writes in Chinese, German, and English, and she has had articles published in prominent law journals. Her topic today, as we can see from the slide, is what data protection can learn from trade secret protection. So over to you.
And first, thank you very much for inviting me to this conference. I find the topics discussed today to be highly interesting. I would like to be involved with a special perspective, what is about data protection. As you have mentioned, yeah, now I see the slide. Yeah. As many of you have already mentioned, data has become one of the most important resources in online competition, and it is left to be decided how are we going to regulate the creation and the use of data to protect one side too strongly would inevitably harm the freedom of the other side. So trying to find out properly between the both sides is a challenging topic in today's online competition. And could you please move on to the next slide? Yeah, thank you. And I take a perspective to compare data protection to the protection of trade secrets. The reason for me to doing so lies in several levels. On one level, because both have the similar origin, they both originate from anti-unfair competition. And another reason is that they both are facing or have faced the same problem. One of the biggest problems they have faced or is facing is that which approach to choose to protect the subject matter. As Trade Secret has experienced this question, it has asked its community whether we should choose the property law approach or the tort law approach. And now the protection of data is facing the same problem. We are now seeing a heated discussion in China whether we should protect the data as if it is a subject matter for property, taking more the approach as if it is intellectual property, or should we protect it more with tort law? For us, for us in the Chinese context, we just use the general clause in our anti-unfair competition law, which regulates that competitors should behave according to the bona fide way and respect honesty and good faith. Yeah, I guess I have to skip some slides. So probably we can move to the fifth slide, the fifth. And here I have cited one article, which has been one of the most influential articles when it comes to trade secret protection. That article has been written by Professor Mark Lamley and has been published in Stanford Law Review in 2008. That was a time when the US IP community was discussing among themselves, actually had already for a long time, whether they should treat trade secrets as intellectual property, namely as a kind of property, or whether to protect the trade secrets more as if it's just another phenomenon in tort law. And the central question for and the central issue for those who argue against a property law approach lies in that they think property law model might grant too strong a protection to trade secret. And exactly against this kind of thought, Professor Mark Lamley has authored this highly cited article. And perhaps we can move directly to slide 14, if that is convenient. Thank you. Slide 14 with some, yes, I think this is the one. So Professor Lamley argued that actually to treat trade secret as if it is a property doesn't necessarily mean that we are granting stronger or even too strong protection to trade secret. And I think what he has said about trade secret might give us some hints when we are discussing the protection of data. So I have put what Professor Lamley has written in his article in original in black, and I have analogously written something similar to data protection. And I think his argument against the tort law approach in trade secret applies exactly also to data protection. So I will go directly to the counter arguments for data protection. I mean, I will argue that to protect data as if it is a property will not grant too strong a protection to data. Instead, it will grant just exactly the right amount of protection to data. So here, I will read just the red highlighted part, which I have written according to what Professor Lamley has written vis-a-vis the trade secret problem. I argue that paradoxically, using property law model to protect the data actually encourages instead of discourages the use of data. Without legal protection, companies in certain industries would invest too much in keeping the data under technical guard. The subject matter requirement therefore serves as a gatekeeper function, ensuring that the law encourages the work otherwise would be prevented from happening. And the next slide, please. Yeah, and so here, the two sub-arguments. First, the theory works only if we treat data as intellectual property rights, requiring, for example, quantity and value elements of protection. If we give the protection to information that is easy to collect, we defeat the purpose and give windfalls to people who may not be welfare-enhancing investors, and we might call them data trolls. Courts that think of data law as a common law tort rather than an IP right are apt to overlook the quantity and value requirements in their zeal to reach bad actors. But it is the courts that emphasize subject matter threshold requirements, not appropriation, as the key element of the course of action that have it right. And the next slide, please. And the second sub-argument is, second, an IP theory of data protection also encourages preemption of unjust enrichment theories and other common law ways courts are tempted to give private parties legal control over information in the public domain. Thus, an IP theory of data protection is in part a negative one. The value of data protection law lies, in part, in defining the boundaries of the course of action and preempting others that might reach too far. So I guess I can move directly to the end slide. To conclude, I have used Professor Mark Lamley's arguments in the trade secret field, arguing that trade secrets should be treated as a property subject matter instead of being treated as a tort law regime, to say that we should also treat data as if it is a subject matter for property instead of only regulate that with a very broad, general, opaque, obscure clause in the anti-unfair competition law. Thank you very much.
Well, thank you very much for
Thank you.
that theory, Jiang. It was very interesting. And we'll get to some questions when we finish the last session or the last presentation. The last presenter that I would like to introduce is Associate Professor Simin Gao, who's Associate Dean Academic of the Law School at Tsinghua University and is a former Deputy Director of our joint centre. And she received her doctorate from the University of Pennsylvania Law School and was a former Russell Ackoff Fellow at Penn's Wharton School of Business. She brings interdisciplinary perspective to a wide range of emerging issues that encompass bankruptcy law, corporation law, financial law, and economic and comparative law. She has authored publications on bankruptcy law, financial law and regulation, and received the Extraordinary Excellent Prize of the Chinese Government Award for Outstanding Self-Financing Student Abroad in 2012, and the Gold Medal of the International Insolvency Study by the International Insolvency Institution in 2017. And her paper is on the indicatorization of insolvency law and its critics. So thank you, Professor Gao.
Thank you very much, Deb, for introduction and invitation. It's my great pleasure to attend today's conference. Today my presentation will focus on indicatorization of insolvency law and its critics. So everyone can see my slides, right? Next slide. My presentation will discuss three issues. The first one is the emergence of quantitative comparative law, and I will use World Bank's legal indicators as example. And the second issue is the methodological problem of World Bank's resolving insolvency indicators, which is the very typical indicators of World Bank's doing business indicators. And the third issue is the effects of World Bank's resolving insolvency indicators and on Chinese legislature and judicature. So that is all questions I want to discuss in today's presentation. Next slide. Okay. As we know, the theory and practice of Chinese bankruptcy law has been deeply influenced by the quantitative comparative law. And if you review the research, legislature, and judicial practice on Chinese bankruptcy law, you can find that they adopt lots of laws from the comparative law from the other countries' bankruptcy law. However, the quantitative comparative law is unable to assess the actual efficiency of the law rather than just simply comparing the rules on text. So we need a better methodology in comparing laws. Next page. And quantitative legal comparison is a new branch of the comparative law initiated by the theory of law and finance, and of which the legal indicators is an important form. According to the definition of Professor Amarius, legal indicators are referred to the measures, standards, and rankings of the quality of law and legal institutions across the entire world, particular regions and selected jurisdictions. The typical example of the legal indicator is the World Bank's doing business indicators, which consists of 10 specific index. And Professor Michaels says that what is the most important development in comparative law in the recent year you have ever heard of? The answer is that the legal origins theory and the doing business report by the World Bank. So we can see that actually the World Bank's indicators is not only index for how the different countries to reform their law system, but actually it has bring the revolution in the comparative law methodology. Next page. However, we can find that there is several problems with the World Bank's doing business indicators. For example, they have a bias in selection of evaluation objects, and they also have many problems with the indexed measures tools. For example, that the selection process for legal notes is not transparent to the public. So the public don't know which legal notes will be chosen for measure. And secondly, the cause and effect relationship measured by the indicators is not certain. The World Bank didn't indicate very clearly why they use such indicator to measure the legal systems in different countries. And next page. And also, I think the World Bank's indicator has a misunderstanding of what is the best practice rule. And actually, World Bank tried to recommend the best practice rule for legal reforms by giving the ranking for different countries' legal system. But the most direct consequence of the best rule recommendation is that many countries will just introduce the short-term reforms to improve their ranking by the World Bank, instead of seeking the most suitable law to boost the economic development, which may lead to the regulatory moral hazard. Next page. And for example, in the insolvency law regime, World Bank has indicator which is called the resolving insolvency, and actually these indicators are originated from an essay which is titled as a debt enforcement around the world. But the methodology used by the insolvency indicator has some problem. For example, it has bias of selecting of the assessment procedure, which only choose the in-court bankruptcy legal regime for assess. But for a debt enforcement methodology, there is not only a formal bankruptcy proceeding, but also the non-formal settlements, which is very important, especially in the developing country. So the selecting of object by the resolving in insolvency indicator actually has the bias in selecting. That is the first problem. And the second problem is that the selection of the creditor rights for access to measure the efficiency for bankruptcy law is not so proper, because actually the secure creditors' right is not good subject to be assessed because they have a specific collateral to guarantee their interest. And the better one should be the unsecured creditors' right. So it means that the subject they choose is not the best one to be assessed for the efficiency. And thirdly, the assessment methodology can truly reflect the recovery rate. Even for the secure creditors, the method used by the recovery rate also fails to truly reflect the repayment rate. So we can find that there is several problems with the insolvency indicators by World Bank. Next page. And World Bank actually emphasize very much on the going concern value, but actually the going concern value is not always go with the reorganization. So the signal which has been provided by World Bank's indicator is that the reorganization is always better than the liquidation, but that is not always true in the business world. And next page. So not only the methodology, but also the best rule the indices can't be read directly as the Bible for legal reform. Because the best rule by the World Bank's resolving insolvency indicator is actually coming from World Bank's principles for effective insolvency and creditor and debt regimes. And most of those rules is actually derived from the US Bankruptcy Code. And the indicators actually choose 16 questions for questionnaire, and those questions are actually extracted from the principles. However, the World Bank doesn't give the reasons why they only choose those 16 questions and how they can evaluate the efficiency for the bankruptcy system for a specific country. So just as the comments from the critics that the World Bank's questionnaire has always intended to be treat the complicated legal issues in a simplified way, and inevitably the dilemma of Ashley's heel may occur. Yeah, that is to say that it's questionable to treat with the complicated issue without a substantive approach that each factor is independently separated from the analysis, while the other factors is be shown in summary. So I think the resolving insolvency indicate can providing the trend for legal reform, but it cannot be used as the textbook for legal reform. That is my conclusion. So therefore, we need to treat the resolving insolvency. Next page, sorry. Go to the next page, to the page 11. So therefore, the conclusion is that we need to treat the resolving insolvency indicates rationally from the perspective of examination oriented. It is reasonable to supplement the part that Chinese still lose points in a short term of time, but it will go astray if it used as the perfect answer and be the ultimate guide for the legislative amendment in the future. But unfortunately, if we look at Chinese judicial interpretation for bankruptcy law, we can find that the most recent judicial interpretation by Supreme Court is actually adopt all the recommendation from the World Bank indicators, although I think that won't be the best rule to be followed in the long term. So that is my conclusion. Yep.
Well, look, thank you for all of our speakers. I think you'll agree with me that the sessions were all very helpful and very interesting across a wide range of areas. I've got a number of questions here for the speakers, and I've got some myself. I'll start from the top. The first one is for Professor Zhang Chenying, and the question is, can you further explain the major trend of China's antitrust law and market regulation and their implications for the world, if any?
Yeah, and the new amendment of antitrust law actually, even in some articles as principle as well. So in the regulations, we give some specific regulations in towards the platform and the digital economy, such as a kind of behavior towards the abuse of dominance, such like self reference, and the in the merger control, we have a new standard for the exam system to start the procedure. Besides, we exceed the turnover, the amount of turnover, and we have a specific regulation in the digital area. Maybe we will give the value, the market value as a kind of standard besides of the turnover. And next is the evidence to the rules is that we give clarification of the platforms in the SAMR. The Bureau gives some new rules to category 3 levels in the platform, such as super big or the others, and so on. I think that's the basis of the regulation. 4 is just drafting. Maybe it can come into effective by the end of this year. Thank you, Deborah.
Thank you very much. And look, I'll move to the next question. The questioner says, thank you for sharing the insights, Professor Healey and Dr. Bai. I wonder whether you would please further explain the major similarities and differences between the China and Australia in the major areas you discussed and any reasons for them. So I think I will give that to you, Sophia Xue Bai, so that you can talk about the fair competition review system, and then I will talk a little bit about the digital platforms briefly. Thank you.
Oh, thank you. Thank you for the question. Like I said, with a major difference is Australia's adopted a broader focus called regulatory impact assessment, or in Australia called regulatory impact statement, which is required all the government when they implement regulations that expect bonding need to consider its impact, and competition impact is certainly one element of this consideration. While in China, fair competition review system is more like competition impact assessment, which is mainly focusing on one factor, that is the regulatory impact, that is the impact on competition, regulatory impact on competition. Well, certainly other factors are considered, but it's in the form of exemptions. Like I mentioned, listed in the my slides, it's national security related, technology related. Those consideration is considered in the carve-out. I hope this is a major difference here. And one similarity I observed is both Australia and China, when they implementing this sort of impact assessment, they all have the aim of integrate national market. In Australia, this happened in the late 90s. There is a human review report which is quite influential. Stated Australia is a single market, and there are different steps, ways to achieve this. Similar trend can be observed in China, especially the new emphasis of united national market. I hope this clarifies things. Thank you.
Thank you very much, Xue Bai. Look, I would add that in the area that I was discussing about digital regulation, I suppose that the biggest, I mean, I've looked at the Chinese amendments to the anti-monopoly law and actually written on them, but I think Australia has taken a slightly broader approach in the sense that in relation to digital, it actually has not amended its competition law at all yet. What it has done is it has been exploring supporting legislation. So it has done the collective bargaining for platforms and publishers. It is proposing amendments to privacy laws. It has implemented a consumer data right to open up markets, which at the moment applies to banks and electricity companies, etc., but will be spread. But there is some suggestion in Australia that they will amend provisions in the anti-monopoly law in relation to mergers and there's a proposed amendment that they might reverse the onus for organisations which are classified as large digital platforms, or maybe as gatekeepers, however they do it, and it may make it harder for them to acquire other potential competitors. But that is the way we've done that in Australia, whereas at the moment I think that there have been a number of changes to the anti-monopoly law which you know, cover a lot of it. I'm just looking, I had a couple of questions. I was going to ask Xue Jiang if she agreed with Professor Lemley's view, and you seem to. You talk about the right level of protection for data. I guess this is one of my questions. My experience is that I was last in China in December 2019 at a digital conference in Shenzhen. And I was really taken by the more laissez-faire approach to use of data, which appeared to be the case in China. The general view put by the speaker on data at that conference was that it would be okay to use data for the common good, so there should not be as many protections for it. In Australia and some other countries, of course, we have a bit of a schizophrenic view of data, because on the one hand, people are prepared to put everything about themselves on something like Facebook, but on the other hand, they want their data protected. So what do you think the Chinese approach really is to data and its use?
Thank you, Professor Healey, for the to the question that is right to the point. Yeah, I totally agree with you that when you attend a conference which aims to deal with the data protection issue, you might hear probably the vast majority of speakers talking about a regime which should allow more freedom to use the data, and also emphasize on the data's protection of data. What kind of effect does this perceivably strong protection have on the public interest? This is what I think is the approach based on the so-called tort law approach. This might sound to be an approach which releases a bigger space of freedom of use for the defendants. But whether it really functions so, I am not quite sure. The reason I compare data protection to trade secret protection lies in that we have seen exactly this kind of debate in trade secret protection. Also there, at first people feared that if we protect the trade secret as a kind of property, we might grant too strong protection. But what people did see in the court was, when we do not require the protection of trade secrets to have a threshold, to have subject matter requirements, to rely solely on whether the defendant has acted in the wrong way, then we will see some kind of some uses which might be allowed, which might be waived under a property law approach, to be caught under the tort law approach. When it comes to trade secret scenario, it has been often that, for example, when the information is not really generally known to the public, when the information is not, when the information is kind of generally known, when the information is actually easily ascertainable, but the defendant has acted in not an honest way, has stolen the information from the plaintiff, then the distinction between the two approaches stand out to be very obvious. Those who follow the property law approach will actually waive the defendant's bad action. Let me put it this way, because they have acted in not an honest way. But those who follow the tort law approach might will be willing to catch the defendant and hold them liability. And when we come back to the data protection, if we do not set a subject matter requirement, requiring that protection of data requires that the data to reach, for example, certain amount of quantity or certain level of substantial investment, for the details we can discuss what should be those requirements for subject matter protection. But if we do not have this requirement threshold, and rather only rely on the fact whether the defendant has actually taken the data from the plaintiff, then on one side, this might be even stricter to the defendants. On another side, this is a much more obscure region to analyze whether the defendant should be held liability. So I totally agree with you that in the forum, laissez-faire approach or tort law approach has many supporters. But when we go back to the traditional areas of discussion, we might have a slightly different view. Yeah, that is my answer. And thank you very much for the question again.
Thank you. I will have one question for Associate Professor Simin Gao, because I know she has to go, or she may have gone. Oh no, she's still there. Great. Look, someone has asked if you could speak in more detail about the significance of the World Bank's doing business indicators for the area of bankruptcy law.
Thank you very much for Deb's question. Yes, I think the World Bank's indicator has very significant meaning for the comparative law. And the World Bank's indicators integrating the best practice rule into the questionnaire and giving the scores of the standardized answers, so that it can continuous and extensively monitoring the legal reform of commercial law in different countries all over the world. And it can do it every year, so it can evaluate the efficiency of different legal systems. Therefore, it can have very large scope of coverage and dissemination compared with the traditional comparative law on the legal reform. Moreover, the straightforward publicity of the World Bank's indicator can make people believe that the relationship between the good law reform and the economic growth, and which can lead to the further legal reform in different countries. And although the World Bank's indicator only focus on relationship between the market and the development of commercial law, but it opened the new era of the comparative law by the revolution in the methodology. So I think it has very significant meaning for effect for the comparative law methodology. Yeah, so that is the answer to your question.
Thank you very much for that. Look, I'll go back to Professor Chenying Zhang. What do you consider the most important amendment of the anti-monopoly law in the context of the digital environment, Professor Zhang?
Thank you. Yeah, actually, the digital business is a kind of special characteristics comparing with the traditional area. In the Chinese antitrust law, I think not only China, every jurisdiction, maybe the same thing. I think for example, the price. I think is one of the most important indicator of judging monopoly behavior, such as to define the relevant markets or the market share and so on. But price is ineffective in the digital economy. In this way, that the SSNIP SNP test, we should modify some of the factor indeed. Besides of this, I think that such as EU, you just mentioned in your pre, that the gatekeeper. I think the internal logic is the same thing. In some factors, we need to, from the other view, to look into the platform business. Besides of this, in the evidence is a kind of hard to for the practice enforcement, such as how to provide the evidence and the supervise for the algorithm collection under the platform. I think it's very, very difficult. And what is more is about the whether the abuse of a self-preference in the market dominance should be completely prohibited or be allowed to just in some kind of context. As like this, I think it's all the challenges to the current antitrust law. The good news is that we now have the regulations. We do think about it, and one of the guidelines just toward this platform and the digital area. I think it will work. Thank you, Deborah.
Thank you. I have another question here for Sophia, which is a question I wanted to ask, but someone else has also asked it. And Sophia, China's wholeheartedly embraced competition impact assessment. How widespread are the exemptions that have been granted? And at this stage, do they make the exercise less useful? The question that was in the chat was, is the low number of exemptions relevant to anything? But is that correct? Are there a low number of exemptions? And what are your comments on all of that?
Thank you, Deb. This is a really interesting question. As I mentioned in my presentation, while the listed exemption factors are helpful, they contain high level of they're very general in nature and may have fall short of detailed application guide. Hence, as personally, when writing the article, I find it's hard to my best knowledge to find an even single case where a policy measures has been exempted from the fair competition review, because all the government are required to publish exemptions if there is any. So to my best knowledge of, yes, there is a low number of exemption case under the fair competition review system. And my personal opinion, I think this situation in a way highlighted the administrative doubts associated with the application of the exemption. In particular, I think abolishing certain anti-competitive provision in a policy measure is far easier and convenient than measuring exemptions factors that require a trade-off. The administrative cost saving of not conducting such exemption test seems to be substantial. And for example, when seeking exemptions under the Fair Competition Review, policymakers are required to explain in writing on why such a policy measure is indispensable for achieve policy objective, and what is the specific period of time for those kind of exemption, and why the policy measure will not severely restrain competition market competition. And even after exemption are granted, policymakers have the obligation of reporting on the competition effect of such exemption on a yearly basis. In a way, to conclude, I think administrative cost for applying exemption under the Fair Competition Review requires manpower, which especially staff with certain amount of knowledge for competition. And this can be difficult to locate within the government administration. And I think this possibly contributed to the low number of exemptions and a fair competition review. Thank you.
Well, thank you, Sophia. And look, I don't think we have time for any more questions. Look, I would really like to thank all of the participants for their outstanding presentations, which I personally found very interesting, and all from different perspectives. A lot of thought and effort has gone into them, and also to the audience for the questions which they posed, which were excellent and right on point. I would also like to thank the CICEL administrators, our centre manager, Fion Chua, and Hannah Jez, for their efforts in terms of preparing for the panel and also conducting all of the online activities that have needed to be done for this for the presentations and questions. So thank you to all my colleagues for their involvement, and thank you for the audience for listening. I hope you all gained something out of it, and I hope you will join us when we have our joint centre conference again next year. Thank you very much.